Birthright citizenship has been one of the most debated immigration issues in the United States for decades. The debate became even more intense after President Donald Trump signed an executive order on January 2025 seeking to deny automatic US citizenship to the children born to the parents who were in the country illegally or temporarily. However, the US Supreme Court ruled that birthright citizenship remains protected under the Constitution, meaning that children born on American soil will continue to receive the US citizenship no matter what. The discussion has major legal, political, and immigration consequences. Supporters say that it protects one of America's oldest constitutional principles, while critics argue that it encourages the misuse of immigration system. The ruling is also closely watched by Indians, especially the students, professionals, and the families living in the US. Why? Because the biggest argument is the favor of birthright citizenship is that it provides legal certainty. Under the current interpretation of the 14th Amendment, children born in the US automatically become the American citizenship regardless of their parents' immigration status. This avoids situations where children could become stateless or spend years fighting for the legal battles over their nationality. It also creates a simple and uniform rule that applies equally on everyone born in the country. Supporters also argue that the birthright citizenship promotes social integration. Children born in the US stay up and grow as Americans, attend American schools, and then enjoy the constitutional rights as other citizens. This has been the key of the country's major identity for over 150 years. Another argument is changing the system that could create enormous administrative challenges. Every birthright would require immigration authorities to verify the legal status of the parents before deciding the child's citizenship. And this would increase bureaucracy, legal disputes, and the government costs. However, critics believe that this policy has serious drawbacks. One of the biggest concerns is that birthright citizenship may encourage illegal immigration or so called birth tourism, however, where some foreign nationals travel purposely to the United States primarily to give birth to their children just to receive a US citizenship. Critics argue that this creates an incentive to the misuse of the immigration systems, even if their parents themselves do not qualify to remain inside the country permanently. Others require the automatic citizenship that it can create long-term immigration benefits for the families. Once the child becomes an adult, he or she may eventually sponsor certain family members or the permanent residents under the US immigration law. Although this process is strictly legal and needs requirements, usually it may take years. Some national security experts have also raised concerns that the citizenship should reflect a stronger connection to the country than simply being born there. There have been concerns that were reflected in the dissenting opinions of three Supreme Court judges who argued that the Constitution continues to deserve a different interpretation. For Indians, the Supreme Court's ruling has mixed implications. First, Indian professionals on H-1B visas, international students on F-1 visa, researchers, and other temporary visa workers who have children in the US will continue to benefit from the legal certainty. The US-born child will remain in America as an American citizen under the current constitutional framework. However, the ruling does not provide any immigration benefit to their parents themselves. Having a US citizen child does not automatically grant your permanent residency with work authorization or even protection from the immigration enforcement. Parents must still qualify independently under the existing immigration laws. The decision may also influence the future family planning for some of the temporary residents. Since the birthright citizenship remains unchanged, families already living legally in the US will not face uncertainty over the citizenship status of the children born there. And at the same time, immigration experts cautions against the assuming that having a child in the US creates easier pathway to the permanent residency. Now, US immigration law remains separate from the citizenship by birth, and a visa holder must continue to follow all legal immigration requirements. Moving forward, politically, the debate is unlikely to end. Some lawmakers have suggested pursuing a constitutional amendment if they want to change the current interpretation of the birthright citizenship. Such a change would require an overwhelming political support and remains highly difficult under the US constitutional process. Now, the Supreme Court's decision therefore preserves the status quo. Yes, birthright citizenship remains one of the defining features of American constitutional law. Supporters view it as a guarantee of the equality and inclusion, while the critics see it as an outdated policy that should not be reconsidered in the light of the modern immigration challenges. Now, in the end, for Indians living in or planning to move to the US, the immediate takeaway is very clear. Children born in America will continue to receive the US citizenship under the current legal framework. But, the broader immigration rules governing visas, green cards, and permanent residency remains unchanged. Meanwhile, the law immigration pathways continues to be only the route of the long-term settlement in the US.